Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. Very recently, Honorable Supreme Court of India, in the case of Sushma Shivkumar Daga versus Madhur Kumar Ramakrishnaji Bajaj, Madhur Kumar Ramakrishnaji Bajaj in diary number 1164 by 2022, dated 15th December 2023, held that, this is more important, held that the cancellation of deed is a right in personam. It's not a right in rem. Particularly, definitely it is arbitrable. You can go to the Arbitration and Conciliation as per the Act, Arbitration and Conciliation Act 1996. Yesterday, for the law of taught students, I told you what is right in rem and what is right in persona. Right in rem is a right accrued against the whole universe. What is a right? So right, please remember, right according to IHERNG, I-H-E-R-N-G, it is a legally protected interest. An interest created by law, protected by law, that is a right. These rights are two types. One is right in persona and second is right in rem. Right in persona means against certain persons. In the case of torts, if you want to file a case against a tortfeasor, so it is your right in persona was violated. Suppose for that I have given the examples also. You have given one of your flats to a person for rent. A gave his house to B for rent. Right? A only has got a right to collect the rent, not every other person. Not a Tom, Dick and Harry can go and collect the rent from him because you have got the absolute right. Maybe you or your deputy or your authorized person. Second, right in rem. You constructed a house, you have a beautiful bungalow, you have got a mansion. Can anybody enter your house without your permission? Can any disturb you? Absolutely no. The entire universe, since you are the owner, they are restrained to enter the premises. They are restrained to disturb your right. Your right is universal. So this is the right in rem and right in persona. But deed, here the important point is cancellation of the deed. Yes, it is a right in persona because it is in between two people, is it not? So coming to the facts of the case, actually the appellants filed for the cancellation of the deed of sale. Actually there were three agreements, tripartite agreements. In two agreements the arbitration clause was mentioned, but in the last agreement arbitration was not at all mentioned. Therefore the appellants, they say that since there is no arbitration clause, then the court has to cancel the deed. Right? The present appellants were the appellants are plaintiffs in a civil suit. They sought a declaration that the conveyance be declared null and void. So previously there was an agreement of sale, some deed was there, maybe gift or settlement deed, that may be cancelled. And registered develop agreements, because tripartite agreement, they may also be terminated. But the defendants, so development agreement is there. They might have started some construction. They might have started the development of the area. Therefore, they approached the court and they wanted to go for arbitration according to Section 8 of the Arbitration and Conciliation Act. What is Section 8? Section 8 postulates that a judicial officer, the court, a judicial authority, based on the arbitration agreement, can direct the parties to go for arbitration. But in the last agreement, there was no clause like that. So therefore, the plaintiff or the appellants, they argued that when there is no clause of arbitration, how can you go? How can the court decide? But in the previous two agreements, the arbitration clause was there. In one agreement, it was there that in case of any dispute, in case it is agreed between the parties, in the event of any dispute or differences between the parties in relation to the agreement or in relation to any other matter concerned with the agreement, the parties shall refer such disputes to the arbitration under the provisions of A and C Act. It is very clearly there. So, the court has extensively discussed how the role of a court in arbitration matters will come into existence. No doubt, it is a very, very limited role, but still, as per Section 8, they can refer the matter to the arbitration and conciliation. So, why? This is also important. It's a wide interpretation. Section 8. The basic purpose for Section 8 is the judicial authority can exercise their judicial vision in the particular incidents. So therefore, yes, 100% quite correct. Cancellation of deed is not a written rem, it's a written personam. Definitely, the people, when there is a dispute between two people, since arbitration is alternative dispute mechanism, yes, definitely the matter can be referred to the arbitration by the court. Normally, in the arbitration clause, they will be appointing certain arbitrators, maybe one or two, like that it happens. But here, the court has taken a good decision. This was right from the lower court. Yes, lower court to high court, same thing happened. So therefore, Supreme Court did not want to interfere. Justice Sudhanshu Dhulia, he has drafted the judgment in this particular case. So friends, I am happy to announce, some people may not be so happy, from the next year onwards, that is from 1/1/2024, I may, please remember, be making videos in the vernacular language or local language. My local language, my mother tongue is Telugu. So most of the students, particularly we are focusing on the young generation, they are not well conversant with the legal phraseology, particularly English. So mixed language will be better, but most of my terminology will be in Telugu. So please bear with me. If the people who are not able to understand, previously I have been receiving the comment section that आप हिंदी में बोलिए, please speak in English, like that. So till now I have been speaking most of the time in English, but I may have to spare some time for my mother tongue. I may be able to explain them extensively in Telugu. So the Telugu knowing people, you get encouraged, and Telugu not knowing people may be somewhat discouraged. But anyway, this is my small suggestion to all of you. I hope all of you will agree for the same and get enriched with the legal knowledge. Thank you very much.